Hello, my name is Andrew Douglas, and I am the Principal Attorney of Andrew Douglas, PA. This video is a brief tutorial on how to fill out a Florida construction claim of lien. Please visit us on the web at douglasfirm.com or give us a call at 954-474-4420. We look forward to helping you with all your construction law and commercial litigation needs. First things first, I want to take you to the Florida Statutes website and show you Florida Statute 71308, which is where we find the claim of lien form that all lieners should use when filing a claim of lien. This is the form we are going to use, and I'm going to show you how to fill out today in this web video. As you can see, my claim of lien form is really essentially the same claim of lien form found in Florida Statute 71308. And now we're going to talk about what needs to go into this lien form to make it valid. Okay, so here's my lien form. The bolded content is the content that needs to be personalized and tailored to your needs. In general, the claim of lien must identify the following bare essentials. First, the name of the liener and the address where notices in process may be served on the liener. You are the liener, and since you are the one placing the lien on the property. Also, the name of the person with whom the liener contracted with or where she was employed. So essentially, if you're not in direct contract with the owner and you're a subcontractor, you had a contract with a general contractor or someone upstream from you in the construction process. Whoever gave you the instruction to provide work or labor to the project, or who you have a contract with who's not the owner, you need to identify that in your lien. That the brief description is installation of window treatments. The lien also must contain the contract price or the value of the work you provided to the project. The lien must also have a proper description of the real property that you provided work for. The more information I feel, the better. In this example, you'll see that I've taken the legal description of the property and also included a post office description or a post office address. At this point, I want to take a little detour from this claim of lien form and show you a little trick of mine. I'm going to take you to the Broward County Property Appraiser's website. There I'm going to show you a pretty quick and easy way to find the legal description of a property. Okay, just to show you real quick, this is the Broward County Property Appraiser's website. You click on Property Search and you accept the terms. Search by owner name, and for example, type in Huizinga for Wayne Huizinga. You see the search results, you find the address you did work on. Let's say in this case it's the 1233 address. You click on the link there, and you can see the post office address and the legal descriptions right there. I'd also double check that with some deeds that were filed in the past transferring this property. You can see the historical deeds, and you just click on the blue hyperlinked link there and it will take you to the public records and show you the documents themselves. And if you want, you could also include the property appraiser's ID number, which is that number in the upper right hand corner of this page, that 5042 number. And that's the easy way to find the information on how to properly describe your property. You have the legal description on this page, the site address, and the property appraiser's ID number if you want to include that. The lien must also contain the name of the owner, as you see here. Even more, it is important that the time when the first and the last items of labor or services or materials that were furnished to the project are identified in the lien. As you can see here, it indicates the date January 1st, 2012, which were the first items delivered, and the last items were delivered on January 10th, 2012. This is very important. The reason why this is important is because when filing a claim of lien, timing is important. By statute, you must file your claim of lien within 90 days from the date of final furnishing of the labor, services, or materials by the lienor. And you are required to put that date of final furnishing on the face of the lien, right here. The date you first provided work to the product is just as important as the last date. And the reason for this is the notice to owner. Okay, now I'm talking about a completely separate form. What is a notice to owner? Not to get too off track, a notice to owner is another statutory form which must be sent by a liener to a property owner when that liener does not have a direct contract with the property owner. And the notice to owner must be sent within 45 days of first furnishing of services or labor to the property. And that is why it's important to place the date that you first furnished labor or services to the property on the lien itself. Now let's briefly discuss if your situation requires you to serve a notice to owner on the property owner. Let me illustrate. If you look at the left-hand side of the graphic, it's demonstrating a situation where the owner has a direct contract with the lien. In such case, since the lienor has entered into a contract with the owner directly, the owner is presumed to have notice that the lienor, that you, are working on the property. Therefore, you can lien his property without sending him a notice to owner. In fact, in this case, a notice to owner is not required to perfect your lien rights. Now let's look at the right-hand side of this graphic. This is a situation where the owner has a direct contract with a general contractor, or someone else besides the lienor. As you can see from the dotted line, that the lienor, or you, do not have a direct contract with the owner, and you in essence have no relationship to the owner, or no legal relationship to the owner. In this case, you are required to file a notice to owner to perfect your lien rights. Now, since the lienor does not have a direct contract with the owner does not know that the lienor is working on his property. The lienor needs to put the owner on notice, essentially saying, hey, I'm working on your property. If I do not get paid by the general contractor, I will put a lien on your property. This is the function of the notice to owner. It is mandatory to perfect your claim of lien on the property. To learn more about a notice to owner, please see my web video on the notice to owner. Finally, I want to go back to the claim of lien form. Now I want to talk about the two dollar values on the lien. First is the total dollar value of the value of work in place, and second is the unpaid amount, which is really the value of the lien. First, let's talk about the total value. Generally, the contract price will be determinative of the value of work. That is the most simplest case, is when you have just a contract value and that's the total value of work in place. Of course, that would occur in a situation where you've fully completed your work on the project. You may also include extras and change orders which were authorized by the owner. However, you cannot include such things as delay damages or other expenses arising out of any breach of contract. In the case where a lienor has not fully completed their work, the claim of lien should not include lost profits on work not yet performed. And obviously should not include work not performed, even if it was in the original contract or the original contemplation of the parties. Now that you have indicated the value of work in place, you have to indicate what you are unpaid for such work. This is the easy part. All you need to do is find out what payments you've received and subtract that from the total value of work in place. And that should be the value of the lien and what is unpaid to you on your construction project. You need to be careful not to put an exaggerated lien amount, because if you do put an exaggerated amount, you could be liable for filing a fraudulent lien. And when you file a fraudulent lien, the owner can come after you for his attorney's fees, costs, and any other damages caused by that fraudulent lien. I also want to go back to the notice to owner for a minute and point out the information that I have here on the lien, which includes the date it was sent by certified mail and the United States certified tracking number. I believe it is good practice to include that certified tracking number on the face of your claim of lien. Now I want to finish up with briefly describing what parties are to receive a copy of the claim of lien. Florida's construction lien law requires that any lienor recording a claim of lien, either before recording or within 15 days after recording, shall serve a copy of the claim of lien upon the owner of the property. Also, in an abundance of caution, I recommend that the lienor send a copy of the claim of lien to all entities with whom a lienor does not have a direct contract with. This includes any subcontractor or contractor above you in the construction contracting hierarchy. Well, that's it for this video. Please feel free to contact us if you have any questions.